So Oregon Measure 114's firearms purchase permit and their magazine ban has been upheld as constitutional by a federal court. But this fight is far from over. So let's talk about this. But real quick before we jump into this video, if you think magazine bans and purchase permits are clearly unconstitutional, go ahead and hit that like button and subscribe. Also want to give you guys some important channel news. I am actually going to be releasing a podcast here on the main channel. Many of you are familiar that I was doing a podcast over on a second channel. I'm just going to bring it here to the main channel. I'm going to be releasing the first one here on the main channel tomorrow, Sunday at 5 p.m. So keep an eye out for that video. I think you guys are really going to enjoy it. It's a little bit different from the content that we're doing, but it's all 2A related. We're also going to be doing some interviews and stuff like that. So I'm really excited for the podcast. It's going to be available here on the YouTube channel, but also it's going to be available audio form, Spotify, Apple Podcasts, all of that. So if you're interested, I will leave a link to the podcast where you can get the audio down below. And also stay tuned for tomorrow, Sunday at 5 p.m. Pacific, when we release the podcast and it goes fully live. As I mentioned in the intro, in this video, we will be discussing some important news in regards to Oregon Measure 114. This is the measure which was passed in the state of Oregon recently, which requires a firearms purchase permit, and then also it creates a ban on so-called large capacity magazines. In response to Measure 114, there were multiple lawsuits which were filed against the state of Oregon. There was the state court case, which was filed by Gun Owners of America, or GOA, and that is called the Arnold v. Brown case. Then there were also multiple federal court cases, which were ultimately consolidated under one judge, and the lead case in those cases is currently OFF v. Kotek. Well, we received a final decision by a federal district court judge who was hearing all the federal cases, and in this decision, the judge upheld Oregon Measure 114 as constitutional. Now, for those not familiar with what Oregon Measure 114 does, let me explain generally what is going on. Measure 114 first requires that anyone purchasing a firearm must obtain a permit to purchase. To obtain the permit to purchase, the resident will need to complete a safety training course, go through a background check, get fingerprinted, show a valid ID, and only after that will you get a permit to purchase a firearm. Now, under the measure, it's not illegal for you to own a gun without a permit, but you will need a permit to purchase any new firearm. However, Measure 114 did not stop with just creating a permit to purchase. The second significant thing that it did is it created a ban on the future sale, purchase, and transfer of what the state deemed to be so-called large capacity magazines. Now, under the magazine ban, it is a prospective ban on the future sale of those magazines. So there were some magazines that could be grandfathered in. That's why originally when this was introduced and passed, there was a huge rush in the state of Oregon for people to purchase magazines. Now, one of the major issues with Measure 114 was that there was no way that it could have actually been implemented by the original deadline. In response to that essentially looming deadline and the fact that it could not be implemented, multiple cases were filed against the state of Oregon to essentially halt it from going into effect. There was the GOA state lawsuit, which was Arnold v. Brown, and then also multiple federal cases. The one we're going to be talking about here, which all the other cases were consolidated under, was OFF v. Kotek. Originally, the federal court judge in OFF put a temporary halt on the permitting scheme from essentially going into effect for 30 days, but the magazine ban, I believe, was allowed to go into effect immediately. However, in the Arnold state lawsuit, there was a Harney County Circuit Court judge, Judge Robert Rocchio, who granted an outright TRO, and that TRO halted the permitting scheme and also the magazine ban from going into effect. Then subsequent to that, there was a hearing on a motion for preliminary injunction in the state court. At that hearing, Judge Rocchio upheld his order to temporarily restrain the permitting scheme from going into effect, and he also said that his order would remain in effect until he received notice from the state of Oregon that they could actually implement their new permitting scheme. After the hearing, he also issued an order granting a preliminary injunction against the magazine ban in the state of Oregon. But there were still those federal lawsuits which were out there pending and looming. The judge in the federal case held an expedited hearing on all of these cases last week, and we received her decision just yesterday. Essentially, she has ruled to uphold the permitting scheme and also the magazine ban. The judge stated in her decision that before this court are two core questions. One, can the state of Oregon limit the number of bullets to 10 that a law-abiding citizen can fire without reloading? And two, can the state of Oregon require firearms purchasers to obtain a permit, which imposes various requirements, including a completed background check, safety training, and consideration of mental health status before purchasing a firearm. After a week-long bench trial, this court concludes that the answer to each of these questions is yes, One of the main reasons she upholds the magazine ban is because she believes that the Second Amendment primarily protects only the right to self-defense. Based on this, she argues that magazines that hold more than 10 rounds are not useful for self-defense and therefore are not afforded the same type of protections. And on that basis, she upholds this ban on magazines. In the opinion, she states, "This court acknowledges that there may be lawful purposes other than self-defense for which an individual can use a firearm. While these uses may be lawful, they have never been explicitly recognized as being the central component of the Second Amendment right. Only self-defense enjoys that kind of unique focus within the Supreme Court's case law. Hunting and other recreational uses of guns have no explicit or otherwise direct protection in the text of the Constitution or under existing doctrine, nor does the historical evidence support such a conclusion. Accordingly, this court finds that the Second Amendment protects an individual right to commonly use firearms for the central purpose of self-defense." What the judge is doing here is narrowing the case law from down below. This is essentially the next phase of the lower courts trying to misapply and narrow the Supreme Court's 2A decisions. Lower courts did the similar thing with Heller when that first came out. You saw the Ninth Circuit and other circuit courts go rogue and try to narrow those decisions, and that's essentially what she's doing here. Then this judge goes on to try and limit the common use for lawful purposes language that is used in Heller and Bruen. She states that arms in common use for lawful purposes means that the arm in question is actually used for self-defense commonly, not that the intent of the owner is to use it or that they are owned for that purpose. She states that this court assumes that most firearms owners purchase their firearms and firearms accessories, such as LCMs, with the intent to use them for lawful purposes, such as self-defense. If the subjective intent of an individual were enough to show that a firearm or firearms accessory is used for a lawful purpose, primarily self-defense, then nearly every firearm or firearm accessory purchased in this country would satisfy that test. And again, she's saying that and she doesn't like that, but the reality is that is actually what the Second Amendment says, and that's actually what the Supreme Court's precedent says, but of course she doesn't like that. And what she's reflecting here in that discussion is the battle right now that's going on versus common ownership versus actual use. Common ownership is the appropriate test, like we saw the Supreme Court use in Caetano. The court there found that 30,000 stun guns owned nationwide was sufficient to prove that those arms are protected by the Second Amendment because they are in common use for lawful purposes. The test was not whether or not 30,000 stun guns were actually used in self-defense events, but that's what the judge wants to do here in this case. So those are just a couple things wrong with this opinion, but there are so many more. I don't even want to go through all of them because it's just this opinion is all over the place. She is misapplying Bruen. She is misapplying Heller. She is not appropriately adhering to the text, history, and tradition of the Second Amendment. And it's really a frustrating decision to read. But the good news with all this is that the Arnold state court case by GOA, the preliminary injunction against the magazine ban, the TRO that was extended, is still in place. So this decision really will not have a huge negative impact right now immediately on the state of Oregon. In the Oregon case, I believe there was a summary judgment hearing that happened last month. And then also there is a full trial set for, I believe, in early September. I would suspect that Judge Rocchio may grant the summary judgment in favor of the plaintiffs. He's already stated multiple times that he believes this magazine ban that's trying to be implemented is unconstitutional under the Second Amendment. And also he's been very skeptical of the permit to purchase process. And then as for the federal cases here that were just decided, they will no doubt go to the Ninth Circuit. So that's what's currently going on with Oregon Measure 114. If anything else develops, if anything changes, of course, I will let you all know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.